Hello, welcome to this forum for candidates for Lackawanna County Court of Common Pleas, 45th Judicial District, sponsored by the League of Women Voters of Lackawanna County and the Center for Ethics and Excellence in Public Service at the University of Scranton and the Political Science Department at the University of Scranton. We thank also Toyota of Scranton for their financial support for this Zoom forum. My name is Diana Daigie, currently president of the League of Women Voters of Lackawanna County. The mission of the League is to promote participation by informed citizens in their government. The League is nonpartisan, which means we do not support or oppose any political party or candidate. The League of Women Voters is an organization of men and women of voting age. I encourage our viewers to join the League of Women Voters, which you can do on our website, lwvlackawanna.org. Membership connects you with 3 levels of the League: county, state, and national. Please be aware that it is, for this forum, it is our policy that no person, candidate, or political group is allowed to excerpt or edit today's forum recording. Campaigns may post a link to the forum where voters may view it in its entirety. Professor Jean Harris will serve as moderator for tonight's forum. Professor Harris is she is Professor of Political Science and Associate Faculty, Women and Gender Studies at the University of Scranton, where she is also Coordinator Ready to Run, Northeast Pennsylvania. Thank you, and I will turn the forum over to Jean.
Thank you, Diana, and thanks for joining us for this forum. We will introduce you to the 3 candidates who are running for, as Diana said, the Lackawanna County Court of Common Pleas. All 3 candidates have cross-filed, which means they are seeking the nomination for both the Democratic and Republican parties. This is an open seat election because there's no incumbent judge running for retention. The winner of each party's primary will compete in the November general election to fill the seat of Judge Tom Munley, who reaches the mandatory retirement age of 75 for Pennsylvania judges in November. So I will now just do a brief introduction of the candidates. Are in alphabetical order. So Nisha Arora currently is general counsel for the ERA One Source Realty in Clark Summit. She's a graduate of Georgetown University, where she majored in government and photography, and she has earned her Juris Doctorate law degree from Villanova University School of Law, and also earned a master's degree in law from the University College of London. Next, we have Mary Walsh Dempsey, currently a senior litigation counsel for Ufberg and Associates in Scranton. She earned degrees from the University of Scranton and Dickinson Law School. And we also have with us Paul Ware, currently serving his 2nd term as magisterial district judge. He also practices law in the Menorah Krowiak and Munley law firm in Scranton. He earned his bachelor's degree from the University of Scranton and earned his law degree from Widener School of Law. Just so you know how we will proceed this evening, I will ask each of the candidates the same questions. They were not provided the questions before tonight's event. Each candidate will have 90 seconds to answer the question, and we will then rotate in alphabetical order. Prior to the beginning of the forum, we drew names and to determine who would go first, and so Mary Dempsey Walsh will be going first. Mary Walsh Dempsey, sorry. With the first question. We will then go in alphabetical order. We will end with each candidate giving a 2-minute closing statement. Again, we drew names for that, and Mary got first draw on that one as well. So now to the first question. So Mary, according to the Pennsylvania Bar Association's Judicial Evaluation Commission, a judge must possess judicial temperament. What qualities and skills do you have that indicate you possess judicial temperament? And please unmute yourself.
There we go. Okay, thank you, Jean, and thank you for having us here tonight. I have been in litigation work for 30 years, and in order to do litigation work and to do it well, you have got to be even-tempered, you've got to be even-minded. You go up against litigants and attorneys. I've had attorneys from large firms who, kind of look at us as small town America. And you've got to keep your head on straight at all times when they insult you during depositions and when they threaten to call federal judges on you. And what I have found all along that has helped, and what my colleagues, I think, have seen in me, is dignity, is respect, is keeping a calm demeanor at all times, is being diplomatic, is being rational, is being pragmatic, always being solution oriented. So in other words, even if I'm in the middle of what I would call a heated case with an opponent who might be trying to get under your skin, always just trying to think of what the end goal is and not getting tied down with the emotion of the argument. So I can tell you that has been a battle many times during my career, and especially as you get older, it gets much easier. Right now, I'm so even tempered. I think people start to wonder about me. It's just something that I've always been able to do, and especially when you practice litigation, you have to be, because no jury and no judge wants to see you out of control. They don't want to see you screaming and yelling. And most judges that I've practiced in front of, and most judges, including the Commonwealth Court, I've had oral arguments in front of the Commonwealth Court. What they want to see is cool, calm demeanors. They don't want to see anybody who's heated or going off the rails at any time.
Thank you. Thank you, Mary. And now we'll ask the same question to Paul. Paul, according to the Pennsylvania Bar Association's Judicial Evaluation Commission, a judge must possess judicial temperament. So what qualities and skills do you have that indicate that you possess judicial temperament?
Dr. Harris, thank you very much. The most important quality and the quality that I've demonstrated for the last 10 years on the bench is actually the ability to listen. Most people, when they get to court, just want to be heard. So if you take the opportunity to respect their position, whether you agree with it or not, and respect them enough to listen to their argument, more often than not, you can maintain decorum in the courtroom. I've been able to do that for the last 10 years, and the same things that I've done and I've learned in my practice as a district attorney for 9 years, trying criminal cases, many criminal cases for years and years, trained me for the opportunity to participate as a magisterial district judge. And that experience for the last 10 years, where I told you that I was able to show my concern for the other side, take the opportunity to listen to whatever their grievances are, and then before you make a rational decision, helps to keep decorum in the courtroom. And I think I've been able to do that. I've demonstrated it for 10 years. And because of that, I think that the Judicial Evaluation Commission would find that I have been an even-tempered jurist for my 10 years on the bench. Thank you very much.
Thank you. And now, Nisha, the same question to you. What qualities and skills do you have that indicate you possess judicial temperament?
Thank you, Dr. Harris. Thank you for hosting this wonderful forum tonight. I think judicial temperament is a character trait that is very important to being a judge. It does encompass the ability to apply the laws to the facts, but also to understand how the decision you are making is going to affect the human beings in front of you. So not only is being calm and collected important, but having a sense of humanity is important also, because as a jurist, the decisions you make are going to directly affect the people who are in your courtroom, as well as their families and friends. And it becomes kind of a waterfall effect of all the lives that are affected by the way that you act and the way that you hold your court. I think judicial temperament also involves patience, open-mindedness, courtesy, and the courage to act in the face of adversity. Sometimes you have to make difficult decisions, and that is part of judicial temperament also. I think that my life experiences bring me to a point where I can exercise sufficient judicial temperament in a courtroom because I've worked in all sectors of the law. So I've been before the judge, with the judge behind the bench, and also in the private sector. And all of these experiences help create a well-rounded personality, which ultimately is what you need as a judge, and the ability to hold everyone accountable for what's going on in the courtroom. Thank you.
Thank you, Nisha. So the next question will start with Paul. According to the PA Bar Association's Judicial Evaluation Commission, attorneys, by reason of education and experience, are well qualified to recognize strengths and deficiencies in the legal system. What are your views on whether the court as a whole deals effectively with racial and gender bias? And please remember to mute yourself. Yeah. You're still muted. I'm sorry. There we go.
When we talk about racial and gender bias, there really is no room for that in the courtroom. Now, we all bring biases, our own personal biases with us when we go to the courtroom, and each attorney, based upon their life's experiences and their education, their client perhaps, bring racial and gender bias to the courtroom. And again, it may be very, very slight, it may be extreme depending upon the case, but each judge, each jurist should do their best to make sure that there is no room for racial or gender bias to affect their ability to hear a case, decide the case on its merits rather than on the race or gender of the parties. So it's because of that that I think that we as attorneys generally do a pretty good job of it. But we're also human beings. We all make mistakes, and we all bring our bit of humanity with us into the courtroom. And it's that humanity which creates differences between us, and it's usually those differences that bring us to court in the first place. So we have to respect each other, racial and gender biases, know that they exist, but know that there's really no room for them in the courtroom. Thank you very much.
Thank you. Anisha, the same question to you. Attorneys, by reason of education and experience, are well qualified to recognize strengths and deficiencies in the legal system. What are your views on whether the court as a whole deals effectively with racial and gender bias?
I have had the opportunity to practice in surrounding counties as well as Lackawanna County, and I will have to say that Lackawanna County does do a pretty good job of dealing with racial and gender bias. As a minority, I've never felt affected by any sort of inherent bias in the court system in Lackawanna County. I cannot say that for the surrounding counties, but I think when you go into the courthouse, you have to go with your head held high and respecting everyone around you, and giving everyone that respect draws that respect back to you also, and removes any of those inherent biases you may be walking into. I think the judges in Lackawanna County do a good job of making sure that all of the people who come before them are treated fairly and with respect. I think that everyone is pretty conscious of the hot topic of inherent bias right now. And I think that the judges and the attorneys in Lackawanna County are working hard to address that. There's a lot of diversity training going on, and I think everyone's kind of making the efforts to educate themselves on the issue of inherent bias and any kind of, systemic discrimination that may be affecting people. Because a lot of times when you are the victim of some kind of discrimination or bias, the person who is affecting that on you may not be fully aware of what they're doing. And as attorneys and as jurists, we have to take responsibility to make sure that we better ourselves every day.
Thank you. And Mary, the question to you. According to the PA Bar Association's Judicial Evaluation Commission, attorneys by reason of education and experience are well qualified to recognize strengths and deficiencies in the legal system. What are your views on whether the court as a whole deals effectively with racial and gender bias? You're still muted, Mary.
Okay, thank you. So I do concur with my colleagues. We do have a tremendous judiciary here who I think has done an excellent job in dealing with it. But I would be disingenuous if I didn't say that I do think statewide and or nationally that this is an issue. In fact, one of the 4 constitutional amendments that we'll be dealing with on the ballot is going to be whether we're going to change Article 1 of the Constitution, dealing with the equality of rights because of race or ethnicity. And that's being done for a reason. Let's be candid with one another. And as we look nationally at what's occurring in the country, in fact, last year when I was elected the president of the Bar Association by my peers, I went in there with 3 words that were my vision: diversity, inclusion and acceptance. And again, while I think our judiciary here is exceptional, I also think there's always room to improve, especially on issues that relate to race, sex, age, disability, national origin, sexual orientation. So I think it's something we all have to be cognizant of every day, whether we're in our private law office, whether we're in court, whether we're on a bench, or whether we're a litigant, because there is inherent bias. And sometimes, again, the whole definition of that is we don't even realize we have it. So I think we're doing a good job. Do I think there's a lot more that can be done in that regard? Absolutely. And I do think one of our main starts is going to be this question that we'll have on the ballot, come May 18th. Thank you.
Thank you. The next question will start with Nisha. If you were the person responsible for deciding what cases would be tried in what order, how would you split the court's time between the criminal calendar and the civil calendar?
I think that's a very relevant question for Lackawanna County right now, because I know the caseload has increased significantly for the judges who are sitting on the bench right now. I think you have to, obviously, the criminal calendar probably needs to be prioritized, because there are defendants who might be in jail, and there's the Rule 600, which means that the cases have to be tried within a certain amount of time. So you do need to make sure that any case that is affecting someone's liberties or freedoms, I think, takes priority over a case that might just be affecting someone's monetary rights. And so I would probably prioritize the criminal calendar over the civil calendar. That being said, I think there does need to be some work done to move along with civil cases, because a lot of times the civil cases are moved along at the pace of the attorneys, and when the attorneys are ready to go. And I think that does create a long backlog, and also makes plaintiffs and defendants subject to the judicial system for longer than they need to be, because there's no reason that a civil case should take 10 years in any case. I don't think that that's something that should happen. So probably that criminal would be prioritized.
Thank you. Mary, the question to you. If you were the person responsible for deciding what cases would be tried in what order, how would you split the court's time between the criminal calendar and the civil calendar?
So my initial answer to that is, because of a defendant's right to a speedy trial, I would obviously have to be extremely cognizant of that. But assuming I was in a position where the people who had criminal trials were up to date, there definitively is a backlog locally in civil litigation, which is primarily where I'm practicing right now. What is happening is we can certify a case for trial, and it could take about 18 months to get to trial. And I really just call that a supply and demand issue. I know our judges are working at 110%, but the demand is the lawsuits and the supply is the judges, and the demand is going up and the judges are staying the same. So I would like to see civil cases prioritized a little more. Again, I know our judges are doing the best they can with what they have in terms of staffing, because we do always have to be cognizant of the criminal, and I shouldn't say criminal, but the right to a speedy trial for someone who is accused. I think one way of doing that, very briefly, just looking to see if I have time, I practice a lot of work in federal court. And what they do in federal court is, right at the beginning, you're assigned to a specific judge, and that judge will follow you right through with an individual calendar. And he or she will do a joint case management plan right at the beginning of the case. And absent good cause, and you have to do it via motion, you're guided by that joint case management plan throughout the case. And it really works well in keeping things on what I would call a stricter time schedule, and you can historically get to court a lot quicker. Thank you.
Thank you. And Paul, the question to you. If you were the person responsible for deciding what cases would be tried in what order, how would you split the court's time between the criminal calendar and the civil calendar?
And while I agree that there is a backlog in civil cases in Lackawanna County, I understand that there are stringent constitutional protections for those that are involved in the criminal cases. And I actually do that right now as a magistrate, where I have to hear civil cases, traffic cases, landlord-tenant cases, and civil cases. So we've got a great plan in place on how we're going to do it. With the dedication to the criminal side, we get a great scheduling order after the preliminary hearing so that we keep everything on track and we meet all sides. Defendants, prosecutors have the right to abide by this agreement so that they know exactly where they stand and when they're going to be in court. And again, the civil cases, when you get there, and they have to rank them in order of how they're going to proceed. But I think the president judge currently does a great job making sure that they push the things that need to be done ahead of those things that we have a little bit more time. The problem we have, especially now in the COVID age, is that we really have to prioritize that now. And I know they put a lot of emphasis on the criminal cases because, like I said, the constitutional protections require that. And the civil cases are increasing the backlog. And I think that whichever one of us is successful and obtains this job as a common pleas judge is going to have to knuckle down and make sure that we are ready, willing, and able to do both the criminal and the civil when we get there. Thank you.
Thank you. So the fourth question, we will start with Mary. Mary, if you observed a party in your courtroom being poorly represented by an unprepared or ineffective lawyer, how would you handle the situation?
I feel like I was asked this question somewhere else. I said to me that I think it's a very tricky situation because historically, I have been in courtrooms as a litigant where I have seen other clients being represented by someone in a less than adequate fashion. What I think you have available to you both as a litigant and as a judge is, in what I would call extreme matters, we could report it to the disciplinary board. I think typically a judge would, you're walking a fine line because you're up there in an independent, impartial role. It's not your job to advocate for either side. It's not your job to get involved with the parties to tell them what they should or shouldn't be doing in terms of, how the case should be tried. What I think could be done is maybe something very informally. And again, if it was a tremendously egregious situation, I think it's a report to the disciplinary board, which is nothing any lawyer ever likes to see happen. But in a contemporaneous fashion, depending on what was going on, I truly think there may be some argument that you have to sit there and watch it. It's a terrible thing to say, but again, I'm not sure your role as a judge is to jump in there and tell someone that they're getting, inadequate representation.
Thank you. The question to you, Paul, if you observed a party in your courtroom being poorly represented by an ineffective or unprepared lawyer, how would you handle the situation?
Well, Mary is correct. We have heard this question before. But when we talk about poor representation, as agents of the court, I think we are obligated, whether it's the judge or the opposing attorney or anyone that is involved in the courts, we have an obligation to make sure that everybody that's there has adequate representation, has a competent advocate, making sure that they're looking after their rights. Problem that we have is, like we said, there are imperfect people in every profession. So we have to address it. The first thing that I would say, and I've done it in the past, is take parties aside, take a lawyer aside, brief continuance, talk about what's going on. And so we will make sure that at least they know that we are aware that something is going on. Because if you just let it snowball out of control, then there's really makes it much harder to get a grasp on it once that's happened. If we have to continue it for a short period of time to address whatever is necessary, I think that's appropriate as well in an informal situation. And lastly, as we talked about, report to the disciplinary board if that's necessary. Now, again, we do a great job of policing our own in Lackawanna County. So we make sure that those that need help get it. Those attorneys that practice in front of us, we talk to them. I had the pleasure of addressing the common pleas judges when I practiced in front of them that would take me into their chambers after a trial and coach and train us what we needed to do better so that we could be better advocates. So those are the things that we have done, and those are the things that we need to continue to do to make sure Lackawanna County has the best bench in Commonwealth of Pennsylvania.
Jean, you're muted.
just realized that. Thank you. So to you, Nisha, if you observed a party in your courtroom being poorly represented by an ineffective or unprepared lawyer, how would you handle the situation?
So I concur with my colleagues that there is sort of a three-step methodology to dealing with the situation. When I was the law clerk, this did happen on a couple instances, and it was the law clerks who brought it to the attention of the judge. The courtroom as a whole sort of knew that something was going on. So what we did in that situation was the judge called the attorneys into chambers had a recess, called them into chambers to discuss what was going on, gave both attorneys the opportunity to explain what was going on, as to not single out the attorney who was not defending his client appropriately. And then what we did was we continued the matter for some time to give everyone a chance to regroup. Ultimately, everyone is human, things happen, but as attorneys, we do have a duty to zealously represent our clients. And if you see an attorney not zealously or effectively representing their clients, you do also have a duty to report that attorney to the disciplinary board. It's a system that has its pros and cons because nobody likes to tattle on their own. However, I think that it is a system that's in place because to have your own colleagues and peers police you is the best medicine against, messing up. And so basically it helps attorneys stay on track also. I guess I agree with everyone else that the final step would be to report them to the disciplinary board, but you do have to have the openness to bring everyone in and try to find out what's going on before you take that drastic step.
Thank you. And so this will be the last question before we go to closing statements. So just to give you a heads up. And we'll start with Paul on this question. So Paul, to what extent have you practiced criminal law, family law, and complex civil litigation?
Could you repeat that again, just to make sure that I understood
Sure.
it appropriately?
So to what extent have you practiced criminal law, family law, and complex civil litigation?
Well, criminal law in particular, I've had the opportunity to practice quite extensively in my tenure in the district attorney's office. I spent 9 years there prosecuting cases actually in the 11 counties of Northeast Pennsylvania in the insurance fraud and the auto theft unit. And I had the opportunity to try multiple drug cases because they were the most frequent in Lackawanna County. So I did have the opportunity to make sure that as far as a prosecutor, the extent of my training and my ability to practice criminal law is quite extensive. My ability to practice family law, I do that now. I'm a member of a private practice and we practice family law, and wills, estates, and family matters are a necessary part, particularly in the Court of Common Pleas in Lackawanna County, where you anticipate that all new judges start in family law. And as far as civil law, I've practiced civil law as well, defending cases, suing people, that sort of thing. And I've also had the opportunity of all of these to hear those cases, which makes me a distinct difference between myself and others. So that's why I think that my experience in all three of those is quite adequate. Thank you.
Thank you. The question goes to Nisha next. So to what extent have you practiced criminal law, family law, and complex civil litigation?
By way of background, I was a law clerk for the Honorable Michael J. Barrace for almost 3 years. And we did it almost exclusively criminal law there. While I was a law clerk, I also had the ability to work with the senior visiting judges, and they handled most of the complex civil litigation. We also helped the non-criminal judges with their trials. If they needed help, the clerks were loaned out to the other judges. So I've seen that both of those types of litigation from behind the bench. I then went on to practice family law with a prominent and very, very busy family law practice. So I was in all of the surrounding counties every day, doing divorces, custody trials, master's hearings. We did PFAs. And then I also did some criminal law in that effect too, because obviously if you have a family law client who's been with you through a divorce, they learn to trust you, and then they want you to help them if they have something like a DUI or small criminal matters. Civil litigation we did also in that law firm. So we did some construction cases, and now I do mostly real estate law. So I've done that also. So it's been a wide variety of law, and all of it is very interesting and fascinating. And I am excited to take this new step to try to adjudicate over all these types of laws. So thank you.
Thank you. And now, Mary, the question to you: to what extent have you practiced criminal law, family law, and complex civil litigation?
I'll start with the easy one first. Family law, I have only guided family and friends through situations. I have never actively represented a family law client. Criminal law, I have done both sides of criminal law. I've spent time with the district attorney's office as a prosecutor. I also did some criminal defense early in my law career. I've tried a criminal defense case and some criminal defense at central court / magisterial level. Complex civil litigation is really where my life has been for the last most of my career. A lot of it, you use the word complex. I've done almost all types of civil litigation, including workers' compensation, social security, disability, personal injury, product liability. Product liability can be considered complex. Wrongful death cases I've had. I've done all types of discrimination work. We talked about that earlier: race, sex, age, disability, national origin, sexual orientation. I've also done class action work and multi-state district litigation work, which is, quite frankly, you're probably only going to find maybe on two hands the number of lawyers in Lackawanna County who've done that type of work. It is complex. It is it's extensive. Most of the time they're put on the protracted list, which is over at the courthouse for cases that are set aside for longer or more complex thing. And the multi-state district litigation, I'm just looking at my time very quickly. That's an interesting type of case. That is a class action that is set up in every state, or however many states you have it in. And so that you don't get a different determination from each judge in each state, they assign it to one judge in one state, but it's each class action. And mine was in Ohio at the time. So really, I've had a very, very varied career in civil litigation, which has been amazing, to be quite frank with you. Thank you.
Thank you. And so now we're going to move to the closing statements. And as I said, we did a drawing to see who would go first. And so Mary Walsh Dempsey will go first with her closing statement, and then we'll go to Paul Ware and then Nisha Aurora. So Mary, and we're doing 2 minutes for closing statements if a candidate would like. So Mary, 2 minutes for you.
All right, and thank you again, everybody. In closing, I would just like to say it's actually been my blessing to practice law for 30 years. To me, it's more than a career, it's a calling. I've practiced law full time. My jobs have never been part time, and I practiced law for 30 full years, well longer than any other candidate in this race. I've practiced both civil and criminal law, as we spoke about through the fruition of the debate, and I practiced in both state and federal court. I've also tried cases in both state and federal court. We talked about my varied practice before. I don't think I need to go through that again. I did spend time as a criminal prosecutor at the DA's office, where I did enjoy doing some community policing and the ability to help fight crime. I had a large appellate practice for about 20 years, and I practiced in front of the Superior Court, the Commonwealth Court of Pennsylvania, and I performed work on cases at the Supreme Court level of Pennsylvania. Commonwealth Court in particular, a lot of my workers' compensation appeals went there, and I had an awful lot of oral arguments in front of the Commonwealth Court, including one that was in front of the court as a whole. On AVO, that's a lawyer rating system. Your clients can go on with or without your knowledge and rate you. I have 16 5-star ratings, which is the highest rating you can get. I don't believe my opponents are rated at all on AVO. I'm also a certified mediator in the federal court system as selected by the judges. I actually got a letter that because of my qualifications, they had asked me to do that, and I went through a 2-day training. I'm also an arbitrator for private matters, which means a lot of arbitration agreements are in place now instead of cases going to court. So the lawyers will pick someone as a neutral or as an independent, where I have to listen to a party's testimony, I have to assess credibility, I have to rule on objections, and I have to write a written and a binding decision. But in addition to my experience, I've also been what I would like to think is a leader in the law community. I'm active with the Pennsylvania Bar Association, and it's not just that I write the check each year that I'm a member. I'm on their Equal Rights Committee, I'm on their Women in the Profession Committee, and I'm the co-chair of their mentoring committee, meaning I help mentor the young women coming in through the state. And in 2016, when COVID hit, it became very clear to us early on that it was going to be a crisis level for lawyers as well. And they picked 16 lawyers throughout the whole state, and only one in Lackawanna County, and I was selected by President Ann John. And locally, I stay involved. Again, mentioned earlier, I was the president of the Bar Association in 2020.
Sorry, Mary, I'm going to have to
Oh.
cut you off. You already went over your 2 minutes and I didn't get my unmute fast enough. So thank you. And we'll move on with closing statements to Paul.
Thank you very much, Doctor. First of all, again, let me thank you for putting on this event, only because I think it's important, particularly now in COVID era, that we can address things virtually and give other people the opportunity to see who their candidates really are. And I start off by talking about service, and service has been a lifelong thing with me. And my son gave me a line once, and he's much smarter than I am. And he said to me, if service is beneath you, leadership is beyond you. So I want to talk about my 16 years at United Parcel Service. And while I was working there as a young man raising a family, I was able to go to law school at night, drove back and forth to Harrisburg 3 nights a week for 4 years while raising a family. It's that type of work ethic that I brought to the district attorney's office, trying cases for 9 years. And the depth and breadth of cases that I tried at the district attorney's office was from one end of the spectrum to the other as far as criminal offenses were concerned. And it was that preparation and that training that qualified me to be a magisterial district judge. And when I got on the bench, and I won in 2011 and was reelected in 2017, those 10 years on the bench, I presided over about 40,000 cases. And I say this to other folks, I actually had to go back and do the math because, you know, I thought that sounded extreme, and it's actually more than that, but I didn't want to brag. So I wanted to make sure that people knew that working hard, doing the right thing every day has been part of what I've been doing forever. And it's that work ethic and the ability to adapt, particularly now in the age of COVID, where all of us had to find new ways to do things differently. So we've adapted in the court. My court is busier than most, as reported in the Scranton Times. And what I'm also quite pleased to say is that we are audited regularly by the Attorney General's office. And my office, public record, was received a perfect score on the last audit done by the Auditor General's office, and quite proud of that. And again, because of my work ethic, because of my life's experience, my time on the bench in the DA's office, I think I'm uniquely qualified to be the next Court of Common Pleas judge. Thank you very much.
Thank you, Paul Ware. And now Nisha Aurora for your closing statement.
Thank you, Dr. Harris, and thank you to the League of Women Voters for hosting this today. It's a fantastic experience for both us and for the community to be educated in what is a very important race. Judges are in charge of a lot in this community in Lackawanna County. Judges, the Court of Common Pleas has such a wide foray in Lackawanna County, and it is a small county where the judges do rule over their own friends and family on a regular basis. It's kind of hard. They say all roads lead to Scranton and 6 degrees of separation. Everybody does know everybody in this town. What I bring to the bench is something new, or what I will bring to the bench is something new. I'm not a part of the political foray. This is my first entrance into politics. I bring diversity. I bring a fresh perspective, and I bring experience, a different kind of experience. I am the only candidate who's actually worked behind the bench with the judges. So I've written judicial opinions. I've sat in chambers and advised judges on the law. The law clerks in Lackawanna County have a lot of responsibility. We are in charge of researching all the law that was applied in the cases. So as a clerk, you sit there and you actually discuss with the judge what the ruling should be and why it should be that. And that is actually the guts of the job of being a judge, is figuring out what the case law is and how to apply that to the facts at hand. I'm the only client who's also represented clients in the courtroom and worked in the private sector. So I've managed profit and loss, I've managed other personalities, and I've managed a lot of independent contractors here at the real estate firm. So all of this varied experience, as well as my varied life experience, allows me to be the best candidate for this position. Thank you.
Thank you, Nisha Aurora. And thank you all. What I will do now is turn it back to Diana Dackey, who will just close out the evening with some comments. Diana.
I'm trying to unmute, thank you. I'd like to thank our moderator, Dr. Jean Harris, for moderating this evening's forum. And the League of Women Voters of Lackawanna County truly thanks the candidates for making time to participate in this voter education program. And thank you to our virtual audience for watching this program. We like to be in person, but we thank you for watching in this format. We encourage all voters to cast their votes in the May 18th election. In addition to this race, there will be primary races for several municipal and county offices. Registered Republicans and Democrats will vote in those primary races. But this May, the election is more than a primary for Republicans and Democrats. There's a special election for the Pennsylvania 22nd Senate District, and this is open to all voters, regardless of party affiliation or none. And the election also includes 4 ballot questions that will ask voters if they agree to change the Pennsylvania Constitution in very specific ways. And so you can find more information about these ballot questions on our website, lwvlackawanna.org. Also on our website, you will be able to find video recordings of candidate forums we recently conducted. Thank you again for watching. Good evening.